My Lord, I now turn to the authorities. I
Yes.
confine my submissions to three authorities, beginning with Kemsley and Foote, as it was decided by the Court of Appeal. That is at tab 18 of bundle 1 of the authorities. And if I could first take you to the headnote, which summarises the position. And it says, criticism of a newspaper proprietor directed to the manner in which news is presented in papers controlled by him is to be treated on the same lines as criticism of a book or a play or other matter submitted to the judgment and taste of the public. And the critic is not to be shut out from the plea of fair comment, because in his criticism he had not given or referred to examples of the conduct criticised, so long as the subject matter of the comment is plainly stated. And there clearly the subject matter is merely the existence of the relevant newspapers. Now, if I can turn you to the judgment of Lord Justice Somerville at page 42. And it's the first full paragraph on that page which begins with the words, "These cases show." And now what Lord Justice Somerville does in these passages, he sets out categories 1, 2 and 3, which I referred to in my submissions. And we say that it's relevant. Well, let me just read that out. These cases show that in criticising something put before the public, as is a play or a book for its approval or disapproval, the defence is, or at any rate may be, open, although there are no citations or examples by reference to which the reader can judge of the fairness of the comment. This is perhaps even more clearly applicable to works of art in the popular sense. A man can criticise paintings or sculpture without producing reproductions of the works criticised. The facts Sir Walter Monckton submits, who was counsel for Mr. Kemsley, in such cases are sufficiently referred to and are available. This is true in one sense, but the object of the article in Maguire's case, which I believe was criticism of a play, was to discourage anyone from paying the price necessary to ascertain the facts. The facts were no doubt available to those prepared to pay for a seat and could be accommodated during the run of the play. In considering whether a comment is a bare comment within Sir Walter Monckton's principle, it is important to consider the subject matter to which the comment is directed. It is obviously relevant that the subject matter is like a book, play or newspaper, something published, submitted to the public for approval or disapproval. And clearly, when one's dealing with that category of information, there needs to be no reference to facts in the words complained of. Lord Justice Somerville then moves on to a second category of facts, and this is where the facts are notorious to the public at large. There is a different class of case to which I will now refer, because it's relevant when I come to consider the case on which the plaintiff mainly relied. The act or acts of a public man, unlike a play after its first night or a book just published, may be both undisputed and under such vigorous discussion at the moment that what might in form seem to be a bare comment might to any reader be plainly referable to that act or acts. I will take an example from the past. Many people regarded those who negotiated the Treaty of Utrecht as having betrayed their country. A bare comment on the loyalty of one of the negotiators might so obviously be understood as referring to the fact of the treaty and the negotiator's part in it, that I would hesitate to say that the writer would be shut out from the plea of fair comment, although there was no express reference to the treaty. And there you'll see that where the facts are notorious, there need not be any reference to them at all in the words complained of. And then he turns to the third category, which we say is relevant on the facts of this case. At the other end of the scale, one may imagine a comment reflecting on the integrity of a subordinate official whose activities had so far received no publicity, where it might be held that the defence was not available unless the facts relied on were substantially set out or indicated. He goes on to consider the judgment in a South African case called Ruse and Stent. And then on the opposite page, page 44, he considers some of the statements made by Chief Justice Rose Innes in the South African case, which was reported in the Transvaal reports. And if I take you to page 44, on the second full paragraph, which begins with the words "in considering." In considering the nature of the defence, the Chief Justice said, "It must be clear to those who read it what the facts are and what comments are made upon them, and for two reasons. Because it is impossible to know whether the comments are fair unless we know what the facts are, and because the public must have an opportunity of judging of the value of the comments." He then cited the passage from Lord Justice Fletcher Moulton in Hunt and Starr. The sentence particularly relied on is the sentence, "If the facts are stated separately and the comment appears as an inference drawn from those facts, any injustice that it might do will be to some extent negatived by the reader, seeing the grounds upon which the unfavourable inference is based." And that really is supporting my general submissions that the stating of the comment has to be done fairly. Lord Justice Fletcher Moulton was referring to cases where comment and fact are intermingled in the words complained of. But the Chief Justice, Rose Innes, extracted a general principle, whether it would be right or wrong, from that sentence. And the general principle was that facts need to be set out in the words complained of. It seems to me plain, and Maguire's case shows it, that there are many cases where the reader cannot judge from what he reads whether the comment is fair or not. The Chief Justice later disclaims the view that all the facts must be set out, but he states that there must be some reference in the article which clearly indicates what facts are being commented on. Mr. Justice Smith, who's the trial judge in the case of Ruse, put it this way: "Can the defence of fair comment be successful in a case in which none of the facts upon which the comment is founded appears in the article itself?" He added, "I think there may be cases where the facts are so notorious that they may be incorporated by reference. It was decided that no facts were indicated or referred to. The comment was in the air, and the plea of fair comment was not available. The defendant could have justified, but he'd not sought to do this." I'm not suggesting that the decision on its facts and in the circumstances as found, applying English law, was wrong. But in considering the general statements made, it is important to bear in mind that the subject matter was the honesty of a director, and that's in fact the subject matter in the case of Ruse. It was not a play, book, newspaper, or exhibited work of art, something put before the public, although it was a matter of public interest, and the public had known of Gillingham's violent accusations. I think that just Mr. Justice Smith's reference to cases where the facts are notorious clearly shows that. It's, however, an abuse of language to say that when a book is just published or after the first night of a play, the facts on which the comment is based are notorious, and yet there is no need to set out or specifically refer to the passages. All that is necessary is a reference to the play. The general statements in that case to which I've referred, if regarded as applicable generally, and particular to comments on published matter, are not, in my view, an accurate statement of the law. So Lord Justice Somerville there is saying that an absolutist stance that facts have to be included is wrong, and that, for instance, in the case of a play or a book, the facts don't need to be included, and he sets out obvious reasons why that's the case.
In the case of a play or a book, there usually won't be any facts apart from the existence of the play or the book.
No, and that's category one. It's an entirely different creature. If I could then ask you to look at page 47. And it's the last paragraph beginning with the word Sir Walter Monckton. Sir Walter Monckton, in his argument for the plaintiff, relied on those words, "facts truly stated," as supporting the view that some facts at least must be stated. I will consider the argument at a little greater length in a few moments, but I will say here that these words, which appear in many judgments of the courts do not, I think, help to decide the question which is before us now. In my opinion, these words apply to every defence of fair comment, however pleaded, and were intended to mean what is now universally accepted, that if a comment is made on facts, the facts, however ascertained, must be true facts. To falsify or distort facts and then to comment on them as though they were true facts would mean that the comment could not possibly be fair, and the defence of fair comment would have no application. And I rely on that passage in support of the submission I made at the outset this morning, that the defence of fair comment cannot apply where the fact set out is an invented fact, as here. Well, Lord, then turning to the bottom of page 50, the very last paragraph, if a defence of fair comment is open to a defendant in commenting on a book offered to the public when no facts are stated, it's difficult to see why a different rule should apply when the subject matter is a public newspaper offered to the public. And one can see there that they're bringing comment upon a newspaper within category 1. Well, Lord, that's the Court of Appeal decision, which was later affirmed by the House of Lords. And if I could now turn to the House of Lords decision itself. If I could again take you to the head note, which is at the beginning of tab 19. And it's really, if I could take you to the part beginning held, that in order to admit the plea of fair comment, it was unnecessary as all the facts on which the comment was based should be stated in the alleged libel. Here, a sufficient substratum of fact was to be implied from the words that the plaintiff was responsible for the press of which he was the active proprietor. The criticism was that the press was low, and any fact sufficient to justify that statement would entitle the defendants to succeed. Failure to establish all the facts given in the particulars of defence would not necessarily disentitle them to succeed. So one can see there in summary the slight oddity of this case. But on the one hand, the court saying it's sufficient that comment is being made on a newspaper, but still says that some particulars need to be given as to establishing that, if you like, there was a reasonable link between the comment that the Kemsley press was low and facts which might be taken to support that comment.
That completely undermines the ratio of the Court of Appeal, doesn't it? The Court of Appeal said it's like a play or a book. You can say it's lousy.
Yes.
You don't have to point to any particular facts. It's just an expression of your opinion about the quality of the newspaper.
Having read the case, and my analysis is not that clear, but at the very least it qualifies what the Court of Appeal is saying. It's not saying commenting on a newspaper is in fact the same as commenting on a book. My Lord, if I could then take you to the beginning of Lord Porter's speech.
Just before we do, it's quite interesting to look at Mr. Kenneth Diplock's argument at page 348. And he gives a very interesting historical analysis of the derivation of fair comment, but particularly at the break in page 348. One is not entitled to comment on the conduct of a public man unless one sufficiently identifies the facts on which the comment is based so that the reader may form an opinion as to the validity of the comment.
Yes.
That was what was picked up.
Yes. It's and then turning to page 353. And I just, the penultimate line, there's reference to salient facts. Which really is saying that a commentator won't need to set out all the facts, but he might have to set out the salient facts.
Which page?
Oh, pardon me, page 353. the penultimate line. And we say this principle remains applicable to category 3 type cases. But then really it's at page 355 that Lord Porter gets into his stride. I take you to the last paragraph of that page. The same observation is true of a newspaper. Whether the criticism is confined to a particular issue or deals with the way in which it is in general conducted, the subject matter upon which criticism has been made has been submitted to the public, though by no means all those to whom the alleged libel has been published will have seen or are likely to see the various issues. Accordingly, its contents and conduct are open to comment on the ground that the public at least have had the opportunity of ascertaining for themselves the subject matter on which the comment is founded. I'm assuming that the reference to a known journal for the present purpose, it is not necessary to consider how far criticism without facts upon which to base it is subject to the same observation in the case of an obscure publication. And I focus there on the reference to the fact that readers at least have an opportunity of ascertaining for themselves the subject matter on which the comment is founded. Then, if I might take you to the last full paragraph, which begins halfway down.
So what do you take that to mean?
It's really a reference to saying, at least with a book, a reader has
a newspaper, I think we're talking about.
Yes, or a newspaper. Factually slightly odd if you're in Newcastle and you're reading a Times report about a play being put on in London, but it's a possibility. The reader has the opportunity to gauge the value of the comment, if I might put it that way.
Well, it's not what he's saying. He's saying at least the opportunity of ascertaining for themselves the subject matter upon which the comment is founded.
It's odd because they will know what the subject matter is. The subject matter is the book or the play. Reading those lines in context, I think it's saying that they have the opportunity of actually reading the book or watching the play, should they choose to do so. Well, Lord, if I can then take you to the paragraph which begins with the question. This paragraph does two things. It sets out the rule of construction that a comment for the purposes of the fair comment defence might by itself be seen as a fact, but when included with other words will be seen as an inference from fact, and therefore a comment such as could be defended under this defence. If I might read that out, and also it puts forward in quite clear language the fact that it's important in the fair comment defence that the facts are fairly stated such that the reader has the opportunity of gauging the value of the opinion. The question, therefore, in all cases is whether there's a sufficient substratum of fact stated or indicated in the words which are the subject matter of the action. Now, I find my view well expressed in the remarks contained in Orders on Libel, 6th edition, 1929. Sometimes, however, he says, it is difficult to distinguish an allegation of fact from an expression of opinion. It often depends on what is stated in the rest of the article. If the defendant accurately states what some public man has really done, and then asserts such conduct is disgraceful, this is merely the expression of his opinion, his comment on the plaintiff's conduct. So without setting it out, he identifies the conduct which he if without setting it out, he identifies the conduct on which he comments by clear reference. In either case, the defendant enables his readers to judge for themselves how far his opinion is well-founded. And we say that's one of the cases, or one of the sources from which Lord Nichols finds his fourth tenet of the fair comment defence. And therefore, what would otherwise have been an allegation of fact becomes merely a comment. But if he asserts that the plaintiff has been guilty of disgraceful conduct, as does not say what the conduct was, this is an allegation of fact for which there is no defence but privilege or truth. The same considerations apply where a defendant has drawn from certain facts an inference derogatory of the plaintiff. If he states the bare inference without the facts on which it is based, such inference will be treated as an allegation of fact. But if he sets out the facts correctly and then gives his inference, stating it as his inference from those facts, such inference will, as a rule, be deemed a comment. But even in this case, the writer must be careful to state that the inference as an inference, and not to assert it as a new and independent fact. Otherwise, his inference will be something more than a comment, and he may be driven to justify the allegation of fact, which must mean proof that the fact is substantially true. Then moving to the top of the next paragraph, you'll see there's a reference to subject matter. Is there then, in this case, sufficient subject matter?
I'm sorry, could we go up to the fourth line down?
But then the question whether an inference is a bare inference in this sense must depend upon all the circumstances. Indeed, it was ultimately admitted on behalf of the appellant that the facts necessary to justify comment might be implied from the terms of the impugned article, and therefore the inquiry ceases to be, can the defendant point to definite assertions of fact in the alleged libel upon which the comment is made, and becomes, is there subject matter indicated with sufficient clarity to justify comment being made? And was the comment actually made, such as an honest, though prejudiced man might make?
Isn't that the question in this case?
Yes, it's one. There are many ways of looking at this
Yes.
case, but it's looking to see if the subject matter,
Is the subject matter of the comment sufficiently indicated with sufficient clarity to justify comment being made? And you say it isn't. It's
No.
not indicated at all,
No.
apart from one
yes,
breach of contract.
yes, and subject matter. Subject matter is the first stage of the inquiry. Subject matter points the reader into the right direction. It points the reader in the direction of the Kemsley Papers or of a particular book or of the notorious acts of a public man. In this case, the reader couldn't be pointed to the facts which we say are only two facts were actually which were in the knowledge of the defendant but not in the knowledge of the reader. And again, in the next paragraph, you'll see then, is there then in this case sufficient subject matter on which to make the comment? And clearly there was, because the subject matter in the form of the Kemsley newspapers was being put before the public. My Lord, you'll see there that at the bottom is and I won't read it out, is the absolute, what I call the absolutist paragraph of Lord Porter, where he says that just the mere inclusion of one false fact will cause the defence to be lost. That means the inclusion of a false fact in the words complained of. My Lord, if I could then take you to page 359. And this is where Lord Porter approves statements made in Hunt and Star newspaper. And on the fifth line, just after the colon, in the first place, comment in order to be justifiable as fair comment must appear as comment and must not be mixed up with the facts that the reader cannot distinguish between what is report and what is comment. See Andrews and Chapman. The justice of this rule is obvious. If the facts are stated separately and the comments appears as an inference drawn from those facts, any injustice that it might do will be to some extent negative by the reader seeing the grounds upon which the unfavourable inference is based. And I interpose to say that's a clear example of, for instance, the allegation being that an MP is racist, which is an extremely unpleasant, damaging allegation to make. But to some extent, the position is ameliorated and made fair, where the defendant also puts in the fact upon which he's commenting, and that's that the MP made a strongly worded speech against immigration. But if the fact and comment be intermingled, and that is intermingled actually in the words complained of, so that it is not reasonably clear what portion purports to be inferenced, he would naturally suppose that the injurious statements are based on adequate grounds known to the writer, though not necessarily set out by him. And this is the point that the reader is taken to be a reasonable person who will assume that if he reads a comment, the comment has been made because the commentator has sound reasons for making it. In the one case, the insufficiency of the facts to support the inference lead fair-minded men to reject the inference. In the other case, it immediately points to the existence of extrinsic facts which the writer considers to warrant the language he uses. In the next place, in order to give room for the plea of fair comment, the facts must be truly stated. If the facts upon which the comments purports to be made do not exist, the foundation of the plea fails. This has been so frequently laid down authoritatively that I do not need to dwell further upon it. And of course, that's subject to the one exception provided by Section 6 of the 1952 Act. If I could then ask you to turn the page 360, and the very last paragraph of Lord Porter's judgment. I do not think it necessary to go through the other cases one by one, but reference must be made to the South African case of Roos and Stent. If I thought the judgment represented a new and independent view, it would be necessary to analyse its reasoning carefully. But in truth, it's founded on the judgment of Lord Justice Fletcher-Moulton in Hunt and Starr, and does not contain any fresh point of view. It is the only direct decision on the point at issue. Admittedly, no English authority determines this question, and for this reason, the reasons I've given, I'm of the opinion that in this case a sufficient substratum of fact is to be found in the words complained of, and I would dismiss this appeal with costs. On the claimant's case is that what's happening here is that Lord Porter, with the support of the rest of the House of Lords, is finding an exception to the rule postulated in Roos and saying in certain circumstances facts need not be set out in the words complained of.
You've read all this stuff from Hunt, and then we go over the page and 360, below halfway, Lord Porter says, the limited measure of the Lord Justice's criticism is to be found in the last sentence, which I have quoted, and I should myself accept it as it stands. Is that the sentence which says, finally, comment must not convey imputations of an evil sort, except so far as the facts truly stated warrant the imputation? Is that what he's approving?
So could you take me to the sentence which you say is approving?
Well, if you look on page 359,
yes,
about 3/4 down, you'll see just below the reference to Joint and the Cycle Trade Publishing Company.
Yes.
See that? Then there's a sentence. Finally, comment must not convey imputations of an evil sort, except so far as the facts truly stated warrant the imputation, which seems to be the last sentence of the quotation from Lord Justice Fletcher-Moulton.
yes.
And so if one looks over the page at 360, at the end of the first full paragraph, the limited measure of the Lord Justice's criticism is to be found in the last sentence, which I have quoted, and I should myself accept it as it stands. What is Lord Porter saying about that, Lord Justice Fletcher-Moulton?
Well,
If it's not just that he accepts that.
What he's saying is that the law up to that point, the starting point, or in fact the law stated, you had to set out the facts in the words complained of. And this case, the ratio for this case, is that in certain circumstances, that's not necessary in order to rely on the defence of fair comment.
Well, what do you want us to take from Lord Justice Fletcher-Moulton? I can ask you that question. You read a lot of it. What do we take from it?
Well, of critical importance is that he is stating the rationale for pointing out, giving some detail regarding the facts which support the comment in the words complained of. Because when that's done, that is when the defence becomes fair, because the reader is being given a chance to gauge the value of the comment, and the claimant, while still being defamed, is being treated fairly, and the damage to him is being ameliorated, because the reader will see to what extent the fact gives rise to the comment.
I mean, he says at 360, about a third of the way down, Lord Justice Fletcher had not to consider whether the facts must be set out in full or whether a reference to well-known or easily ascertained that was a sufficient statement of those relied on. Facts were all set out. And the only question which the court had to consider was whether the comment was honestly made. I mean, I don't get the impression that Lord Porter was over keen on Lord Justice Fletcher Moulton's statement. It seems to me that he had been quite tying them down a bit, saying, well, after all, he's only dealing with these particular matters.
Well,
I may be completely wrong as to...
all I can say whilst I'm on my feet is what we say is taken from it, that you can see the general principle there of treating a claimant fairly. It is derived from that. And Lord Porter sets out that statement as a basis for fair comment. But in fact, Lord Porter just doesn't do it there. Of course, he does it without any ambiguity when he's quoting approvingly of Odgers on page 356, where he approves the statement in Odgers where there's a sufficient reference to facts in the words complained of. And Odgers says the defendant, by doing so, enables his readers to judge for themselves how far his opinion is well-founded.
And then he says, and then Odgers says, and therefore, what would otherwise have been an allegation of fact becomes merely a comment.
Yes.
But why does it therefore become a comment?
Because...
I mean, why can I not think of something being a comment, even though I can't myself tell whether it's well-founded or not?
But this passage in Odgers is dealing with the fact that comment, for the purposes of a fair comment defence, doesn't really bear its dictionary definition, because it's often an inference from other facts. And the comment becomes defensible as comment because in context the reader can see it's an inference from those other facts. And what you see in Odgers, which you see in a number of, in these older authorities, they tend to speak really in this as facts being necessary both to construction and also, and we say independently, important to the fairness of how the comment is presented. Because some indication needs to be set out of the facts on which the comment is based. Well, the judgment in many respects isn't clear, but we do say it is clear in the respects upon which the claimants rely upon it. In regard to Kemsley, if I could lastly take you to the first paragraph of Lord Oakes's judgment. My lords, I agree. The forms in which a comment on a public matter of public importance may be framed are almost infinitely various, and in my opinion, it is unnecessary that all the facts, and I emphasise the word all, the facts on which the comment is based should be stated in the libel in order to admit the defence of fair comment. It is not, in my opinion, a matter of importance that the readers should be able to see exactly the grounds of the comment. So one can see there it's not necessary to set out everything. It's sufficient if the subject, which ex hypothesi is of public importance, is sufficiently and not incorrectly or untruthfully stated. A comment based on facts untruthfully stated cannot be fair. What is meant in cases in which it has been said that comment to be fair must be on facts truly stated I think it's the facts so far as they're stated in the libel must not be untruly stated. Now here we say that's not a reference to category 3, because the reader will be wholly in the dark in situations like that, but will be a reference to cases of notoriety. Well, lastly, if I could take you to the case of J.B. Jeyaretnam and Gokok Chong, which is at tab 16 of bundle 1. It's interesting to see J.B. Jeyaretnam, who was leader of the opposition in Singapore, who was serially abused by the libel laws in Singapore by being sued by the likes of Gokok Chong, who was the Prime Minister, actually suing in this case as the claimant. My lords, the words complained of are set out at page 1111. And you'll see they're quite short. STP had their inaugural earlier this month. Mr. Jeyaretnam attended. After Mr. Jeyaretnam had spoken, he left the hall, and when he left the hall, 200 participants left with him. I believe the exodus was engineered. I don't think it was a spontaneous exodus. If it were, it did not speak well for the SDP. It shows that the crowd, the limited crowd, still looks towards Mr. Jeyaretnam for the time being as a leader of the opposition. But I'm inclined to believe that the exodus was contrived by the leader of the Workers' Party to show who is boss at this stage. And surely Mr. Chayam cannot take that trick lightly. Now, not surprisingly, given the words used there, a defence of fair comment was raised. And if I might take you to the bottom of page 1113. At H, and this is Lord Ackner. It is, of course, well established that a writer may not suggest or invent facts and then comment upon them, on the assumption that they are true. If the facts upon which the comment purports to be made do not exist, the defence of fair comment must fail. The commentator must get his basic facts right. Then you see underneath is a reference from London Artists and Littler, and there's a reference to basic facts. The basic facts are those which go to the pith and substance of the matter. Now, if I just ask you to turn the page to the bottom of page 1114, you'll see that Lord Hewson, who was acting for J.B. Jeyaretnam, whilst Lord Hewson's complaints are strictly justified, in the Lordship's view, the pith and substance of the matter was that after the plaintiff had spoken, he left the hall without any explanation being given for his departure, and that he was then followed by a very substantial number of the audience. It matters not that he was followed immediately or almost immediately after he left, or that the proportion for the audience which immediately or almost immediately followed him was a half or two-thirds of the total number of the participants. It then sets out Section 9 of the Singapore Defamation Act, which certainly on my reading appears to bear a striking resemblance to Section 6. One can see from this case the emphasis on the pith and substance of what's set out in the words complained of. The facts that weren't true didn't cause the defence to fail, because in applying Section 9, it was felt they didn't go to the pith and substance of the words complained of the comment complained of. Whereas in this case, we say that the false quotation very much does go to the pith and substance and leads the reader in a wholly wrong direction.
It's identical to Section 6.
Yes. My Lord, unless I can be of any further assistance, those are my submissions.
Thank you very much.
Before I start, may I just flag up an issue in relation to costs? I see from the practice direction that one has to raise this at the hearing, although obviously it's a matter for the court whether it prefers for it to be dealt with after the judgment.
I'll deal with it afterwards. It would be more convenient if we have submissions on costs after judgment.
I'm most grateful for that indication. Clearly there are important aspects of principle raised by my learned friend's submissions, but I just want to start with a very narrow point in relation to the facts, which in my submission gets my fair comment defence back on the record, even on the test that is being put forward by my learned friend. And it is this: it is the false fact point. The false fact being so fundamental, as it is said, to the comment defence. Now, the principle for which my learned friend contends is you lose your comment defence if the false fact has altered the meaning to the claimant's detriment or has enhanced the credibility of the meaning. I submit that must be materially altered the meaning to the claimant's detriment or has enhanced the credibility of the meaning. That's my understanding of the proposition that is being put forward.
Just say it again.
Well, I take it from 12b of the respondent's case, which
12b,
my lord. It's page 5 of the case, page 53 of the bundle. I think this is the statement of principle. I take issue very strongly with this as a statement of principle, but let's say for the moment this is a correct statement of principle. That where the false fact is fundamental to the meaning conveyed by the words complained of, you lose your defence. Or, perhaps putting another way, where the inclusion of the false fact has altered the meaning to the claimant's detriment, or enhanced the credibility of that meaning. If this is right as a principle, obviously we'd have to have a jury direction, and the jury would have to try and understand these various concepts and apply them to the facts of the particular case. But clearly, in terms of the second sentence, it must materially alter it to the claimant's detriment or materially enhance the credibility of that meaning. So if we had a situation, for example, where the misquotation had been your contract holds no water in law. Instead of holds no water in legal terms, holds no water in law. Well, that's a false fact on one view of it, because it's not an accurate quotation from the words from the email that was sent by the first respondent. Or the omission of your contract is merely a formality. Again, that could be said to be a false fact, and it hasn't accurately reproduced what was said by the first respondent. So clearly it can't just be any misquotation which would somehow deprive you of an otherwise valid comment defence in relation to what are statements of opinion, proceeding on the basis that these are statements of opinion. So it would have to be a material alteration, particularly in the case of a misquotation. It would have to be a material misquotation, so that the message from the claimant's communication has been distorted to the detriment of the claimant or to enhance the credibility of the meaning, which I suppose amounts really to the same thing. And my point is simply this: a jury could, without being perverse, conclude that the misquotation was not material for the reasons that I've submitted and that have been discussed. It would be clearly a jury question. The fact that we have the comment defence, which has withstood the various attacks on it through the lower courts, means that is a jury finding that is open to the jury. Mr. Justice Eady allowed that to be a jury finding, potential jury finding, notwithstanding that he struck out any reference to breach of contract, following his finding that there'd been a breach of the regulations which in fact invalidated the contract. So I'd lost my allegation of breach of contract, but he allowed me to keep in my meaning of contemptuous, cavalier approach to contractual obligations through the email. So,
Sorry, what did he allow you to keep in, looking at your defence?
well,
Of
you can't
relevance?
really tell. You can't tell from the defence because that was the defence that was before the court. And then what happened was that I had to redraft the defence to remove any reference to a breach of contract. The point being, of course, that nobody knew about the regulations at the relevant time. And so I think there's some reference in the judgment of Mr. Justice Eady to saying that I'm perfectly entitled to carry on with my case in relation to a contemptuous approach to contractual obligations because no one was aware of these regulations at the time. It would have been different if the claimants had got legal advice to the effect that they weren't bound by the contract, but that was not in their mind at the time. So what I'm trying...
Paragraph 57.
I'm most grateful. Yes.
Sorry, what are we looking at?
It's paragraph 57 of the judgment. It's tab 4 of Appendix 1, page 38. So at this stage, I've lost any allegation of a breach of contract because of the judge's application of the regulations. But notwithstanding that, I'm still entitled to allege that the respondents have shown a cynical and cavalier attitude to contractual obligations, including reliance on that email. But even if we have a principle, and I'm going to be submitting very strongly that we have no such principle, but if we do have a principle that if your inference is stated to be based on a fact, and that fact is untrue, you lose your defence, it must be that it's untrue in a material way. And the submissions that are being made to the court by my learned friend are these, that by using the plural, you're going from a specific criticism of a specific contractual term into a more general observation as to adherence to contracts. And that the reader of the posting complained of would have assumed that this was a breach of contract between a band and a customer, as opposed to a band and an agent. And all I'm submitting for this very narrow purpose, on the basis of the points I made when I took the court through the wording of that email, that a jury, without being perverse, could conclude that the claimants were saying something more general about their approach to contractual obligations. In other words, putting it shortly, that the misquotation is not as material as is being submitted by my learned friend. And that must be a live issue for the jury.
Shortly, you say, if you get home on justification, you lay the foundation for your fair comment.
Yes, but there's probably still some benefit for me having a fair comment defence in relation to those opinions. But if we are getting to the stage where I've got to prove the substantial truth of my underlying facts to have a run at my comment, we are getting very close to having to prove the truth of your comment. Which is why one of the reasons in which I submit that this approach is fundamentally flawed. But I'm just starting here on the basis of my learned friend's test to say that my comment defence should still get home on the basis that a jury would not be perverse to conclude that that change, that adding of an S, did not materially alter the meaning to the claimant's detriment. And the fact that I have my justification defence is conclusive on this issue. It's perhaps also helpful to just remind ourselves of the Rath case, Rath and Guardian newspapers. Now that was a situation where the false fact was that the claimant sold vitamin pills in South Africa to people in the townships who had AIDS. In fact, he gave them away. And Mr. Justice Tugendhat asked the question whether that fact was completely false, partly false, or not really false at all. And in my submission, a similar approach can be taken in relation to this misquotation. I mean, to what extent is it really a false fact? And what was the answer to that question?
There was more than one fact in the sentence, and the material part of the sentence was not whether the pills were sold or given, but whether those who were ill with AIDS were being deceived into taking something which was of no value to them.
Yes, but on my learned friends test, you'd probably be out on that basis, because it might make a material difference if you're giving them away and they're not really having a huge amount of benefit. That's one thing, but to actually profit from it is another one in terms of moral seriousness. Or one could argue that point. But at the end of the day, it comes down to the jury to make that determination, if indeed that is the test. And I'm assuming for the moment I'm just being limited in my factual material to those words from the email, which I quite clearly shouldn't be, but let's assume that for the moment. Just remind ourselves what exactly Mr. Justice Tugendhat said was the appropriate test. Rath is to be found at tab 30. And it's paragraph 88. I'm afraid there's no page numbers on the judgment. But in the present case, for the reasons given by Mr. Caldecott, I cannot conclude that defendants have no real prospect of proving any of the statements of fact upon which they rely. I do not think it right at this stage of the proceedings for me to decide whether the fact that the claimant donates rather than sells vitamin pills makes a statement that he sells them wholly untrue or only partly untrue. And assuming that the statement is either wholly or partly untrue, the significance of that in the context of section 6 and the other facts set out in paragraph 63 above does not appear to me to be sufficiently clear for me to make a ruling at this stage. And in those circumstances, I cannot conclude that defendants have no real prospect of succeeding in their plea in reliance of section 6, that is, of failing to establish that the words not proved to be true do not materially injure the plaintiff's reputation, having regard to the truth of the remaining charges. That is an issue that in the present case cannot be disposed of at this interlocutory stage. As I pointed out in my opening, in fact, Mr. Justice Tugendhat has misstated the section 6 test. He stated the section 5 test, so it's actually, he's raised the bar. But even if that were the test, that the element of falsity in the quotation has to be shown to be non-material in terms of the element of truth when one looks at the email, I've still got a real prospect of convincing a jury that I can satisfy that test, which is evident by virtue of the fact that I have my justification defence. It's quintessentially a jury matter. But when we come to a jury trial, as we will in any event, but hopefully we come to a jury trial with fair comment, it's very important that when the jury gets their directions, that those directions are clear, that the principles are clear, so they can, as the tribunal of fact, apply the principles to the law. And that is, of course, why we are here in this court today. In my respectful submission, we're here essentially because, well, not for this reason, but as is summarised by the learned editors of Duncan and Neal in the 2009 edition, which reflects a consensus and a concern that has been there for very many years. So if I could just ask your Lordships to go to Volume 2 of the Authorities, tab 44, 1305, page 132. I respectfully submit that one has to ground oneself in why we are here. In Slim and the Daily Telegraph, Lord Denning, Master of the Rolls, said, "The right of fair comment is one of the essential elements which go to make up our freedom of speech. We must ever maintain this right intact. It must not be whittled down by legal requirements." And then the learned editor's comment. There are many other judicial pronouncements stressing the fundamental importance and breadth of the defence. Nevertheless, it may be doubted whether English law has succeeded in avoiding the legal refinements against which Lord Denning cautioned. Some aspects of the defence remain unclear, and defendants who have sought to defend their words as comment have, from time to time, found themselves embroiled in complex disputes of fact or law which suggest that, in practical terms, a defence of fair comment can sometimes be just as onerous, I would add, or more onerous, than a defence of justification. I started my submissions by emphasising the importance of principle. If there are to be elements of this defence, they must be approached on the basis of principle so that everyone knows where they stand. For example, if there is a requirement in order to establish this defence that a reader must be in a position to judge how well-founded the comment is, well, we should just simply state that as a requirement or just discard it as a requirement. If it is to be a requirement, it would probably have to be determined by the jury. And it's quite a vague requirement. The more uncertain the law, the more vague the principles, the harder it is to establish. The costs of litigation become greater. Do they benefit the ordinary person? No, it doesn't benefit the ordinary person. It benefits the person with resource, with money, who might want to put some pressure on a newspaper. This defence must be user-friendly to both sides, to the claimant and to the defendant, and clarity is extremely important. And the fact that it's got to be determined by a jury makes it all the more important that it's clear. We've had lots of examples about situations where injustice could be worked against a claimant, situations where false vindication may be obtained by a claimant. At the end of the day, it all has to be determined by policy, because there are inevitably be situations where injustice is going to be caused. The underlying policy of this defence is the protection of comment. And not just simply the protection of it, the encouragement of it by virtue of the protection which is given to it. My learned friend referred to the case of Watson and Chief Justice Coburn, talking about the smarting from the keen sense of wrong public men who have unfair comments made against them, but recognising that the nation profits from this. And in my submission, it is appropriate to have a little look at Gertz and Welsh, which is a Supreme Court decision from the United States. Of course, the last time that this country's highest court heard a fair comment defence, the net result was that the US courts determined that our law was repugnant to freedom of expression and refused to enforce the consequential judgment that flowed from the House of Lords findings in Telnikov that the words were arguably factual and not comment. So this is simply a reminder in terms of underlying policy, which I submit is equally appropriate to our country and to the European jurisprudence. It's tab 57 of Bundle 2. And the relevant passage is at the bottom of the first column of page 805. We begin with the common ground. Under the First Amendment, there is no such thing as a false idea. However pernicious an opinion may seem, we depend for its correction not on the conscience of judges and juries, but on the competition of other ideas. But there is no constitutional value in false statements of fact. Neither the intentional lie nor the careless error materially advances society's interest in uninhibited, robust and wide-open debate on public issues. New York Times and Sullivan. They belong to that category of utterances which are no essential part of any expedition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. Chaplinsky in New Hampshire. Just pausing there, there is a distinction being made between fact and comment. This case is about comment. It's not about fact. If there are defamatory facts, there's a remedy, existing remedy. This case is about protecting the parts of the publication which are opinion. And then Mr. Justice Powell says this: although the erroneous statement of fact is not worthy of constitutional protection, it is nevertheless inevitable in free debate. As James Madison pointed out in the report of the Virginia Resolutions of 1798, some degree of abuse is inseparable from the proper use of everything, and in no instance is this more true than in that of the press. Any punishment of error runs the risk of inducing a cautious and restrictive exercise of the constitutionally guaranteed freedoms of speech and press. Our decisions recognise that a rule of strict liability that compels a publisher or broadcaster to guarantee the accuracy of his factual assertions may lead to intolerable self-censorship. Allowing the media to avoid liability only by proving the truth of all injurious statements does not accord adequate protection to First Amendment liberties, as the court stated in the New York Times and Sullivan. Allowance of the defence of truth with the burden of proving it on the defendant does not mean that only false speech will be deterred. The First Amendment requires that we protect some falsehood in order to protect speech that matters. Now, all this is being said in the context of false statements of fact. I mean, how much more important is it that we should be protecting opinions which apparently are possibly unreasonable opinions or unfair opinions? We can only do this if we don't make the defence too difficult, too uncertain, so as to put people off. That is the problem with the defence so far. And how a jury could possibly understand some of the principles that are being contended for by my learned friend, I do not understand. The courts have been moving in a, we would say, a more liberal direction. My learned friend kept referring to fairness as being some form of element of this defence, but it clearly is no longer anywhere near a requirement. It might be helpful just to see what Mr. Justice Eadie said recently in the case of Branson and Bauer. Fundamental observation about the importance of this defence. Case involving Richard Branson, who was unhappy about certain comments that were made by Tom Bauer about the lottery bid that he was putting forward. The case is found...
Sorry, which tab is that?
It's tab 3, my lord.
3?
Yes, bundle 1. Perhaps paragraph 26 is the best statement of the underlying principle. On page 747. It is well settled that a defendant does not have to persuade the court, whether the judge or jury, to agree with his opinions, although the remarks of Lord Justice Fletcher Moulton and Hunt and Starr might be taken as suggesting the contrary. Nor yet should he have to demonstrate that honestly expressed opinions fall within some elusive and nebulous margin of what is reasonable or fair. Freedom of speech is not a game to be played according to an umpire's subjective assessment of what constitutes fair play. Moreover, one could hardly fail to notice that if there ever was within this jurisdiction a generally agreed set of standards as to what was reasonable behaviour, it has not survived intact in the less homogeneous society of today. It is important that one should be able to conduct one's affairs and regulate one's speech with some degree of assurance, if necessary with the assistance of legal advice, as to what the likely consequences may be. If the touchstone is honesty, that has the great merit of being a straightforward criterion, not least for jurors to put into practice.
And then it appears to approve what Lord Nichols says in Hong Kong case.
Well, the spirit of, yes, I mean, if we continue in the next paragraph, it's clear there is a significant inhibition upon freedom of speech if one is required to prove the unprovable. A commentator may be able to prove facts objectively, but it's neither just nor logical to seek to subject opinion to the same test. To impose a test of reasonableness or fairness is to bring in objective criteria which have no place in the context of subjective opinion. The objective standards, coupled with the need to have a genuine belief in what is said, are adequate to keep the ambit of permissible comment within reasonable bounds, per Lord Nichols in Cheng. I would respectfully submit that the approach of Lord Nichols in Cheng was entirely correct in the sense that he recognised the fundamental importance of the expression of opinion, that it was something to be encouraged, and he asked himself, is this particular requirement necessary for the protection of reputation, bearing in mind the underlying purpose of the defence? Now, the particular requirement that was in issue in that case, to which Lord Nichols directed his very sharp focus, was whether malice includes a dominant improper motive, or whether it should be limited to an absence of honest belief in the opinion.
Just help me with paragraphs 30 and 31. I mean, he's quoting Lord Nichols on the crunch paragraph, and apparently
Yes.
says that's absolutely clearly the position.
Yes. Could the notional honest person express that opinion on the basis of the facts accurately stated in the article, the facts referred to in the article, the facts that are so well known they may be described as general knowledge? That bit is dealing with the factual pool or the envelope of facts.
Yeah, then he quotes Lord Nichols in the paragraph that you challenge.
Yes.
Says, see to similar effect, or just stretch them open. Then, having said apparent difficulty, he then says 5 lines up, that may be so, but at least the law is clear in this respect. It's long been recognised, etc., etc., etc. So, I mean, that doesn't seem to me to support your approach.
Well, he does go on in Lowe, which is a subsequent decision, to reconsider this point and reaches a conclusion in Lowe that it's not a requirement of the law of fair comment that the reader should be in a position to judge how well-founded the comment is. One has to read this in the context of Lowe. Neither of these cases were being looked at from the perspective of Section 6 in any event. I mean, if one is taking into account the views of Mr. Justice Eadie as judge in charge of the jury list, lengthy experience of conducting defamation cases, they are apparent from Lowe and associated newspapers, where perhaps we should just go to that.
Tab 23, paragraph 56 and 7.
Yeah. So, in having considered the matter carefully, the issue having been raised more directly on the facts of Lowe, he disagrees with Lord Nichols.
Well, we've looked at this passage already, haven't we?
Yes, I mean, I just went to Branson and Bower just to underline that we're not in the territory of reasonableness or fairness or anything of that sort, and just to emphasise the policy factors underpinning this defence. What is the position in relation to Section 6 of the 1952 Act? If I can make the position clear as far as my submissions are concerned. My first broad submission is that Section 6 protects my client, or arguably protects my client, to the extent that the matter should be determined by the jury at trial. And my second point, and I apologise if this didn't come across clearly, is that my client does not need to resort to Section 6 because he's adequately protected by the common law. And by the common law, I include what your lordships could do if your lordships wish to do it. I mean, we've heard many different statements of principle. Some might be inconsistent with others, but at the end of the day, your court is the first time that the most senior court in the land has considered this defence post the Human Rights Act through the taxonomy of Article 10 rather, and Article 8 if appropriate. And your lordships are entitled to formulate the common law principles as your lordships see fit. The reason why Section 6 arose, and it arose for the first time in the Court of Appeal, was that my client was faced with the argument in the respondent's notice that his comment defence must fail because of a misstated fact in the words complained of, namely the misquotation from the email. Whether rightly or wrongly, it has been perceived that at common law, a comment defence will or may fail if there is a misstated fact in the words complained of. Self-evidently, the purpose of Section 6 is to protect the defendant from that argument. It was in this context that my client sought the protection of Section 6, in the same way as my learned friend Mr. Caldecott in the Rath case, which in that case was regarded as acceptable by Mr. Justice Tugendhat, or at least an issue for the jury. It is a requirement of Section 6 that the proved facts on which the defendant seeks to rely must be alleged or referred to in the words complained of. And my submission has been that a jury would not be perverse to hold that the Bibis breach, the email of 27 March, and the landmark breach were all referred to in the words complained of. Having said that, I have also submitted that a defendant at common law is or should be entitled to rely on any facts which are capable of sustaining the comment, irrespective of whether they are referred to in the words complained of. This is apparent from my written case. If I can take the court briefly to it, it's in the core volume at tab 3.
Paragraph?
Paragraph 4. The most problematic area of fair comment has been the relationship between the comment and the supporting facts. The appellant submits that the position at common law should be or is, I put should be or is because of any potential uncertainty and to emphasise that it's a matter for your lordships. The supporting facts do not have to be stated, indicated or referred to in the words complained of. They don't have to be in existence at the date of publication or within the defendant's knowledge. Well, that's a different issue. But 4.3 is also relevant to Section 6. Inaccuracy in relation to any factual allegation the words complained of should be irrelevant to a comment defence, other than requiring the defendant to establish other factual or privileged information capable of supporting the comment. A slightly narrow approach in relation to 4.1 would to say that the supporting facts do not have to be stated, indicated or referred to in the words complained of, providing the subject matter is identified, which a learned friend is contending for. Clearly the subject matter here is at least arguably identified. It's the contractual behaviour of these claimants. That's obvious. And then I say in paragraph 6, aspects of the wider case may not be consistent with existing case law. These submissions will proceed on the basis that the Supreme Court has the power to reformulate the defence in the manner contended for, if it thinks fit. In particular, the defence is entirely a creature of common law other than Section 6. The effect of accepting propositions 4.1 and 4.3, namely no need to reference and inaccuracy is irrelevant, is that Section 6 would become otiose. However, none of the propositions are contrary to Section 6.
I'm not sure I've quite answered. What's the breadth of your proposition? That, I mean, how far outside the point being the actual point, which is, I mean, how far outside if you first say let's say to a failure to fulfil a contract, yeah, to in this case here where you didn't respect the rebooking, where there wasn't respect. I mean, how far can you justify a comment that somebody's unreliable when you commented on that and then that's not proved, let's just say? I mean, can you take anything else, just anything, to show he's unreliable?
Well, it would have to be something on which an honest person could rely to form that view.
Yes,
so
but anything,
I'm sorry.
But would it have to be unreliable in relation to contracts?
Well,
or what? I mean,
my argument, my position is this, that if it could be material to the view taken by an honest person, then it is permissible to rely on it. If it is germane to the comment, because the honest person test requires that person to be in a position to express the opinion on the basis of the facts. So that inevitably involves some nexus between the opinion and the facts within the honest person test. And beyond that, I submit that nothing is necessary.
Wouldn't he have to know of these facts?
I mean, that is another issue, but I submit that he should not have to do so. I mean, lest it be thought that these are particularly radical submissions. I mean, at the moment, there's a bill that's being debated, which dispenses with any requirement whatsoever to make any reference to the facts in the words complained of. That can be found at tab 42 of bundle 2.
This is Lord Leicester's bill,
Yes.
is it?
Why are we looking at this?
I'm sorry?
Why should we look at the bill?
Show you're not making it all up yourself.
I mean, I can't, I suppose, I mean, it's a matter, if your lordships would not be assisted by it.
Well, the more you show us the bill, we're more inclined to say, well, if Parliament's thinking about it, let Parliament think about it, and it's not for this court to start changing the common law today.
Well, this court has, in my respectful submission, this court has a duty. It is a public authority.
We have a duty to listen to you, yes.
No, wider, not the narrow duty just to hear my submissions on this point, but a duty to ensure that fair comment is properly protected. That's my submission. I can derive that from Article 10. I can derive it from the Human Rights Act. Article 10 is, fair comment is a fundamental part of the way in which English law, common law, provides protection to reputation. As a public authority, this court cannot act in a way that is inconsistent with a convention right. And in my submission, that brings with it an obligation on the court to test, by the necessity principle, anything which stands in the way of a comment defence being defeated. Because every time a comment defence is defeated, there is a penalty which is imposed within the meaning of Article 10.2. There's a penalty imposed for the expression of opinion. And so one has to check this defence and all the elements, give it an MOT, which it hasn't had for a very long time, to ensure that it is Article 10 compliant. In other words, that every requirement that you put in the way of a fair comment defence succeeding is necessary. That is exactly how Lord Nichols approached the matter in Chain. But he approached it just in relation to what constituted malice. And he said, bearing in mind what you have to prove to establish defensive comment, it's not necessary to prevent someone from advancing a comment defence if he has a dominant improper motive. He wasn't focusing directly on the question of what facts you could rely on in order to support the comment defence. So this court has an obligation, in my submission, to MOT test this defence and discard and clarify, because clarification is equally important, because clarification and uncertainty inhibits freedom of expression. But this draft bill has no precedent value, obviously. I mean, it's simply something that I was going to illustrate that my submissions are perhaps not as radical as one might seem. It's quite clear from clause 3.6c at the bottom of page 3. Perhaps one has to look at the starting words of clause 3.6. In relation to the facts or material relied on by the defendants providing a basis for the opinion, no account is to be taken of A, anything that the defendant does not show, provided that the defendant shows that condition 4 is satisfied on the basis of what is shown. So that's complete tolerance to inaccuracy, providing there's a sufficient factual basis. B, whether the defendant first learned of the facts or material before or after publication. And C, whether the facts or material were or were not included by reference or otherwise in the publication. I mean, that is the widest possible factual pool to draw on to sustain the comment. And condition 4 is simply the honest person test. Is that an honest person could form the opinion on the basis of the facts or material shown by the defendant in satisfying condition 3. Condition 3 is simply the existence of one or more facts or privileged material. This is sweeping away all these unnecessary requirements. Very simple test for a jury to apply.
Test which opens the area of inquiry to not merely what facts did the commentator have in mind when he made the comment, but what facts in the world are there that, had he known of them, might have justified the comment.
Yes.
It's quite an ambit of inquiry, isn't it?
Well, the inquiry is defined by the defendant. It gives just because the defendant's got a very wide range to draw from, it's up to him to decide how far he wants to go, and obviously the extent to which this is a time-consuming exercise depends on the extent to which the facts are admitted or not. I mean, a defendant could perhaps choose some fairly uncontroversial facts and be satisfied that that was going to be enough to sustain his opinion. But we don't have to have all these unnecessary inquiries about exactly what was going through the defendant's head at the time. And the 9 principles that Mr. Justice Eadie set out in this regard in Lowe. So I do say that Section 6 is available to me. I also say that I don't need it. In relation to its availability to me, there are some further submissions I would like to make in response, which I hope I can make fairly briefly. First is this, and your Lordships will know that Section 6 is in tab 39 of Bundle 2. And I make these submissions in the context of my overriding submission. This defence must be approached on the basis of principle. The first point is that Section 6 does not discriminate between different types of comments. There's nothing within the wording of Section 6 to think that there are 3 types of comments, for example, each of which are going to be treated differently. And if there were to be 3 types of comments, each of which would be to be treated differently, and each of which would have different requirements in relation to them, one would have a very difficult day in front of a jury, and it would be extremely difficult to predict the outcome of these types of cases, because presumably there would be different factual pools that would be available to the defendant according to whether you had a category 1, 2 or 3 defamation or comment, but one wouldn't know if we had a category 1, 2 or 3 comment presumably until we'd had a decision from the tribunal of fact about which side of the line the particular comment fell. And we'd have a large amount of jurisprudence about the distinction between the various comments. And we would be getting the refinements and technicalities which Lord Denning was referring to in Slim. The next point in relation to Section 6 is it doesn't discriminate between whether the facts were publicly available or not. There's nothing there which says you can rely on facts alleged or referred to in the words complained of, or those that are notorious, or those that have been published to the world at large. And bearing in mind that this was an issue that arose in Kemsley, very easy for Parliament to discriminate in some way, so that the comments which related to matters that were not notorious would perhaps have a more onerous burden in terms of identification in the words complained of the factual material. And if we are going to put a more onerous burden in cases where the information is not publicly available, who decides whether it's publicly available and who decides exactly what the burden is and who applies that to the facts of the particular case, particularly bearing in mind that many comments now are being expressed on the internet, on bulletin boards. We don't have this situation as we may have had in the past with the printed press, that something is either notorious or it's not publicly available. Lots of things are publicly available these days, but may not in practice be known to many people. The next thing that we don't see in Section 6 is any requirement for there to be an explicit link in the words complained of between the fact and the comment. So, in a case such as this, where it said, following this communication for this reason, and then you state the comment. So you have your fact, you have your connection, you have your comment. Section 6 doesn't prevent you from going to other facts which are alleged or referred to in the words complained of. There's nothing in the wording of this section which limits you to those facts which are explicitly linked to the comment. The only requirements are that the publication consists partly of allegations of fact and partly of expressions of opinion. And I think it's common ground that we're in this territory in this case. And that the comment defence doesn't fail because one or more of the allegations of fact are not proved, untrue, invented, whatever it may be. The mental state is irrelevant. If the expression of opinion is fair comment, i.e. the honest person test, is satisfied, having regard to such of the facts alleged or referred to in the words complained of as are proved. So, what are the facts alleged or referred to in the words complained of? Looking at the entire publication. Have they been proved? And if so, could an honest person express the comment on the basis of those facts? And if this section is applied properly, then my client must be entitled to go before a jury and seek to rely on the material that's in 9.3 to 9.15 of his defence. I suppose one should cater for the possibility, at least theoretical possibility, of a finding from this court that, say, the Bibis breach of contract was arguably referred to in the words complained of, but the landmark breach of contract was not, or maybe the email was not referred to. In my submission, bearing in mind how low the honest person test is for a defendant to surmount, particularly the interim stage, I could sustain this comment on the basis of the Bibis breach of contract alone, which my learned friend appears to accept was referred to in the words complained of. I could sustain it on the email alone. As a matter of logic, I could sustain it in relation to both. So any decision on the landmark is not really going to be material to the outcome of this case, but in my submission, that is a matter for the jury. Whether this is sufficiently referred to, whether it's sufficiently relevant to the honest person, I would be submitting to the jury that it very clearly was. And certainly it was something that was in my client's mind. And when one looks at the words, "You neither helped nor hindered my diary," then the conduct in relation to the landmark, which we say was a deliberate breach, something better just came along, becomes highly relevant to the assessment of whether an honest person could express opinions about the likelihood of the claimants honouring their contractual obligations when it suits them to try and find a way out for their own benefit. Have been unable to abide by their terms of the contract clearly includes the possibility of on more than one occasion. Your Lordships will be aware of the decisions on meaning. Meaning is a classic case for a jury, particularly in something like this, something written by lay people. Interpretation to be put on it should be made not by lawyers, but by lay people. And that's one of the reasons why we have trial by jury. And then just some very small minor points. My learned friend submitted that the comments became comments simply because they were preceded by the misquotation from the email and then the words "for this reason." I'm not quite sure of the principle.
I thought that there wasn't any issue now in relation to comment.
Yes, but I think it's being suggested that those sorts of comments should be treated differently from other types of comments. I'm simply making the point that if that was a relevant principle, that the jury would have to decide. I mean, the principle would be this. It would be if the comment only becomes a comment because it's linked to a particular fact and it's stated to be an inference from that fact, and if that fact is false, then it can't be fair comment, then there'd probably have to be an inquiry about whether the sole basis on which the comments became comments was the preceding factual statement. And if that is the principle the jury would have to apply, I'm simply making the point that it would be open for me to submit that those comments at the end of the posting are not comments simply because they follow "for this reason." A jury could think they were comments in any event because they're essentially predictions as to the future. They don't rely on the preceding words "for this reason" in order for a jury reasonably to construe them as comments. Inevitably, a prediction of something in the future is a subjective assessment. It's a conclusion. And finally, this. I note your Lordship's understandable reluctance to grapple with some of the wider points that I made in my written submissions, as did my learned friend Mr. Caldecott on behalf of the media, but I would urge the court simply to do one thing that everybody has been asking, that this tort is changed, the name should be changed. Mr. Bennett is making submissions to this court about fairness, and of course your Lordships are judges and can understand how a tort may have changed in its elements. But in my submission, it is extremely prejudicial for a defendant in front of a jury to be faced with submissions as to fairness in the context of a tort which is named fair comment very easy for them to slip into the view that the comment has to be fair, notwithstanding a direction from the judge.
What should we call it? Honest but unfair comment?
Oh, unfair comment, I think, would be...
You'll be happy with that?
Unfair, yes, absolutely. Our unfair comment. Prejudice and obstinate, in brackets. Comment. I've gone for comment for, I think, a number of reasons. One, the reasons are set out in my written submissions. One, because it's possibly wider than opinion. Secondly, because honest comment would suggest that honesty is part of the tort. It's not necessarily part of the tort. It's an objective test. It only becomes subjective if the claimant chooses to allege malice. Without that, there's nothing objective about it. Nothing involving requiring proof of honesty on the defendant.
Sorry, what is your preferred title for this defence?
Comment.
Sorry?
Comment.
Comment.
Comment. Defence of comment. I think Lord Nichols recommended comment. The Court of Appeal recently in Singh suggested honest opinion. I say honest should not go there because it's not an element of the defence. So when one has qualified privilege and offer of amends, which are two defences in defamation, which can be lost if the claimant proves dishonesty, they're not necessary elements of the defence, but they're means of the defence being defeated. They're not called honest qualified privilege or honest offer of amends, whereas there's a defence of innocent dissemination, and that reflects the fact that the defendant must prove his innocence to establish the defence. So I think that I don't have it to hand, but I'm pretty sure that Lord Denning, or one of the distinguished judges who've considered this before, has suggested that honest should not go into the name of the tort for this particular reason. So for years, people have been suggesting that the name of this tort should be changed, and I would invite this court to do so. I think that Mr. Caldecott may have something. I'm not sure whether Mr. Caldecott's got anything further he wishes to say, but those are my submissions, unless I can be of any further assistance to the court.
No, thank you very much.
Well, it's entirely a matter of your lordship. So there is something I would like to say about the core issue, having heard Mr. Bennett. There is a little time, if I could use it, it's entirely a matter for your lordship.
Very well.
Well, I'm very grateful. I'm conscious that this is an indulgence. Can I just say this to start with? The issue, of all the issues, but one issue in this case is of profound importance. There are three possible approaches to qualifying facts which have been argued before your lordships, and it's perhaps appropriate that I find myself in the middle. There are three of these. The first, which I understood Mr. Price at one stage to be arguing, is all facts or any facts that might support the defamatory comment. The second, which I understand to be Mr. Bennett's position, is only facts which are referred to or set out, say for A, the artistic cases, and B, facts already notorious. There is, however, we say, a very important different formulation, which is that the common law...
Is this the third?
This is the third law, I'm sorry, number 3, the one which I will contend for and have done so far, is that what the common law allows is reliance on facts within the subject matter of the comment, but with this crucial proviso, provided that subject matter is sufficiently identified. Now, I don't shrink from saying that while it can well be said that the first gives inadequate respect to Article 8, and indeed, arguably, perhaps to proportionality, The second,
You mean
so-
eight? I see,
the
yes,
first
eight,
one, the
yes,
very
yes,
wide one, you
yes.
rely on absolutely anything which might support your comment disgraceful, for example.
I see.
That could be said to be too wide, too disproportionate, too insensitive to Article 8 problems. But we do say, conversely, that the second solution has enormous Article 10 problems. One only has to look at Mr. Bennett's concept of notoriety being the limiting factor outside the artistic sphere. The moment when comment is most intently required and indicated is when a new event of public importance enters the stage. It may be the adequacy of equipment in Iraq. It may be all manner of subjects of the highest possible public interest. And when it first enters the public domain, public knowledge of the underlying facts will by definition be extremely limited. There may be all sorts of internal ministerial goings-on, scientific views expressed, all which bear on where blame might lie, if blame should lie at all. The idea that a commentator appearing on Radio 4 in what by needs must is a 4-minute slot has to set out all the facts or indicate them sufficiently in order to be able to rely on them is wholly inimical to Article 10, as it is in relation to a letter or any other form of public opinion. The new controversy element is not something that's been mentioned before, but it is at least one, and there may well be others, but it is at least one potent argument against the notion that notoriety should somehow be the all-defining criterion outside artistic works. Now, the second point I would make, it also follows that with great respect to Lord Nichols, the jurisprudential basis for setting out or referring to the facts, namely so the reader, listener, viewer can form his own opinion, is with great respect deeply flawed. One then comes to the restriction which we argue for and which we say was the one which was applied in Kemsley, which is a sufficient indication. The word used is clarity. And obviously clarity must be judged in the round, looking at what the purpose of this defence is. Now, in Kemsley, what was identified was actually not individual facts. You would have had no idea which newspaper to look for, which article to go to, which month, was it the photographs, was it the private coverage, was it the foreign reporting? You haven't a clue where to start. But what you do have is a factual envelope. The subject matter is sufficiently tightly defined. Once you know who Mr. Kemsley is, and the context of the piece, as your lordships will remember, is actually a criticism of another newspaper, the Evening Standard. And the headline was lower than Kemsley, his being a totally different newspaper.
Yes, Lord Beaverbrook might have brought an action.
Not exactly. I think the opposite was that he didn't sue, but Lord Kemsley did. Yeah. So, but be that as it may, the point is that in that case, what was indicated was actually not facts. What was indicated was a well-defined, sufficiently clear boundary. Now, that's why we argue for this middle solution. Now, of course, it's true that the more notorious a matter is, the less you may have to say in order to identify what the boundaries are, because a fair amount of definition would already have been done by the issue having been ventured to and fro, or, in the case of Kemsley and Foote, simply by what Mr. Kemsley does. He's a newspaper proprietor and he publishes known newspapers. So there's a sufficient body of work which is identifiable, or body of conduct. Now, there is, as we know, a close interrelationship between the question of is it a comment at all, and I want to answer Lord Walker's observation about the Australian judge, which I do understand it. It's there is a problem lurking here which is not easy to resolve. I think it needs slightly reformulating. The crude, the MP is a racist in view of what he said. The problem with that is that it doesn't really doesn't indicate any real subject matter other than the allegation that he's a racist. It's simply the allegation. But the moment you say, in view of his opposition to immigration, as expressed in his speech in Parliament last week, you are indicating quite clearly an envelope. Now, if, as I say, in fact he said exactly the same thing in the leaflet, but he didn't say it in his speech, it would seem completely absurd that you should be excluded. But your envelope is clear. It's simply opposition to immigration, not racist in the more extreme sense of the kind that Mr. Bennett was talking about. Now, where one gets into difficulty is when you say X is a racist isn't an expression of opinion. I mean, in one sense, it obviously does read, if I say that, that's my opinion. But I think that the real analysis is this. It's not that it doesn't read or isn't perceived to be an opinion. The problem is that the subject matter isn't sufficiently indicated to allow it to be defended as an opinion. In other words, it fails that sufficient clarity test, and therefore it has to be proved to be true. This is all balancing subtly different competing interests between Article 8 and Article 10. And the sufficient clarity test is where the balance is tried to be struck between the claimant's interests and the defendant's interests. Now, obviously, Section 6 figures in this debate because either Section 6, if my learned friend Mr. Bennett is right, Section 6 is an absolutist statement about when the defence will succeed. In other words, you don't have to prove all the facts, but they have to be referred to or set out in the words complained of. It becomes a fairly absolutist statement about the defence. But we say, and your lordships know why, we say it is something completely different. It's actually there to mitigate this particular harsh common law rule, which is where specific facts are set out in words, you had to prove all of them. Vaguely equivalent to the problem in justification, where you had to prove all the charges, whatever their disparate gravity. Now, one of the critical questions, of course, is why are the words in respect of words consisting partly of allegations of fact and partly of expression of opinion? Now, just pausing there for a moment, the words lower than Kemsley don't consist of any allegations of fact at all. So Section 6 cannot be applying across the board to all types of publications. It's dealing with the publications where the facts are in the article. And as I say, even if you take lower than Kemsley to be a reference, broadly speaking, to the newspapers he publishes, it's still not a reference to specific facts.
Well, Section 6 doesn't apply in that case because there is no statement that's inaccurate.
Well, that's right. It is in one sense a bare opinion with a corpus of envelope outside it.
What interests me is the last two lines. Do you or do you not accept that the last two lines are simply a statement of the circumstances in which there can be a defence of fair comment?
Well, I don't accept that.
Well, then you've got to have a special defence if you've got an inaccurate statement which differs from the defence that would normally be there.
But Lord, My reading of it is this, that prior to this section, if you set out the facts on which the comment was based in the words, if you're in that class of case, you had to prove all the facts. Well, this is simply saying that in that class of case, you now don't have to prove all of them. And I don't take the last two lines as to be making some more general dynamic statement about the law of fair comment more generally. It's dealing simply with that common law rule. That would be my submission.
You say it applies where I put in the article, you're an untrustworthy man, you've cheated on your wife,
Yeah.
and you don't pay your bills in the club.
Yes.
Now, you might fail on one or other of these, but if the remaining one was enough to support the comment, that would be good enough.
That's precisely what it's dealing with.
That's fine. That example, all the statements are alleged.
Yes.
They're allegations of fact. But how about this reference to or referred in the words complained of?
Well,
Referred to in the words
yes,
complained
Lord, there's obviously, there is room. It's one of these troublesome words which can be read in many different ways. My reading of it is it's a sufficiently specific reference to be close to an express factual reference. It's the kind of thing I was talking about yesterday. What he says on page 48 of his book is outrageous. It doesn't actually set out what he said, but it's a reference to what he said. Because our submission would be that that is a fact, a specific fact incorporated by reference. Because the common law rule, that's what the common law rule appeared to be concerned with, which Lord Porter, we can see from his report, it's set out in some detail. In fact, he came out, what he recommended was a slightly different solution to the one Parliament adopted, but that's a complication mercifully we don't have to look at. Lord, can I just say this about having myself referred to Lord Diplock when he was in Silk, and it is a very interesting address on the history. But one has to bear in mind, A, he was an advocate, and B,
Yes.
he was representing the plaintiff. And C, of course, he lost on the very point he was arguing on 348. Lost only to a degree, because one has to accept in Kemsley that, as I say, it's quite clear that there was an envelope indicated. Now, Lord, I don't lose sight of the fact that fixing where the envelope isn't always entirely easy. I could make some comments on the facts of this case, but plainly shouldn't. But there plainly is a line to be drawn. One has to have regard to proportionality. One has to have regard, broadly speaking, to whether there's a sufficiently prescribed area of conduct that is being criticised. But what, on behalf of the media, I have to say we would view with enormous concern was the idea that you have to set out or refer to the facts, save in cases where they're notorious. Apart from anything else, the investigation of whether they're notorious or not, having to talk to someone about whether they're going to go into all the facts, which facts, how many facts, it becomes unworkable.
It seems to me it goes further than that, because in some ways, the more notorious a subject is, the more room for argument there will be. I mean, to mention one topical example, the origins of the war in Iraq. I mean,
Yes.
that is a subject of as great public interest as anything you could think of. But if one says, what are the notorious facts about it, well...
The other point, Lord, is this, that the selection of the facts that matter is itself so often a matter of opinion. I mean, if you've sufficiently defined the envelope, then you select the facts which can be proved. But the truth is, the facts that are out there, some of them will be untrue, some of them will be half true, some of them will be thought by some to be relevant, by others to be irrelevant. I only mention this to show that if you start imposing a sort of notoriety sieve, it becomes almost impossible to apply sensibly in any public interest debate before the event. Also extremely difficult immediately after complaint. But generally speaking, in a public interest debate, there is some degree of delineating the boundaries so everybody knows, broadly speaking, what sort of conduct is being referred to. Broadly speaking. It is more difficult in this sort of case when it arises from a relatively private dispute, which leads to a publication to a relatively narrow class of people. And without commenting on the merits in this case, well, I can see that that sometimes raises rather more difficult questions. But the one thing that we would very strongly oppose is any suggestion that outside artistic works and the truly notorious, whatever that means, the facts must be set out or referred to. Because that really would be, we submit, a very heavy restriction on Article 10 and really unacceptable in modern conditions.
So depart from Lord Nichols.
Lord, I do depart from Lord Nichols. Can I just say this, that both in Reynolds there was no argument on the test, and in Cheng, where it's substantially taken from Reynolds, he was focusing on malice. And where plainly, with all respect to him, he was trying to liberalise the defence and not restrict it.
I think perhaps one can see where it starts to come from. It has much more of a flavour of the First Amendment, the American jurisprudence, and Mr. Price mentioned at least twice in his opening the famous metaphor of the marketplace in ideas, which I think was Oliver Wendell Holmes, wasn't it?
But it was.
If it is a marketplace that you're thinking of, well, then you want people to be persuaded that yours is the best to buy. But we're so far outside the field of the American jurisprudence on political discourse, really.
But yes, and I think that's what Gertz is talking about, the idea that the truth will win in the end. I think so, rather how Judge Lonedown put it. It's a slightly optimistic view, but there it is. As your Lordship says, that's not the territory we're in. Lord, can I just thank you again for, and that's all I have to say on the case.
The Court is grateful to Counsel for their submissions and will take time to consider its judgment.